In the year 987, along the cold shoreline of western Norway, a legal assembly gathered under open sky. Stones marked the boundary of authority, voices carried across the wind. What was spoken there would decide not only disputes over land and blood, but the limits of a woman's life inside marriage. The fear did not come from blades or battle. It came from words spoken calmly, publicly, and backed by law. For many women of the Viking world, what their own husbands were permitted to do under that law was worse than death, because it was meant to be survived. This was not chaos, this was order. In a society remembered for exploration and courage, there existed a quieter system of control, enforced not by raids, but by rules.
Women lived inside households where the law stood with the man who owned the land, the weapons, and the reputation. Marriage was not primarily a bond of affection. It was a contract of power, and once entered, the law followed the husband into the private space of the home. If you are watching dark inquest history, you already know that the most dangerous systems are not always violent on the surface. They are legal, normalized, and rarely questioned by those who benefit from them. What Viking law allowed husbands to do was worse than death. To understand this, we must step back into the Scandinavian world between the 9th and 11th centuries. This was a time without centralized kingship in many regions, where authority rested in assemblies known as things.
Law was memorized, recited, and enforced by community consensus. There were no prisons in the modern sense. Justice was social, financial, and reputational. Honor mattered more than mercy. And inside that structure, women existed in a legal position that was defined, limited, and closely monitored. Viking society was stratified. At the top were free land-owning men. Beneath them were free women, whose status depended on their male relatives. Beneath them were enslaved people, whose lives were controlled entirely by others. A woman could move between these categories through marriage, capture, or accusation. What she could not easily do was escape the authority of her husband once bound to him.
Marriage transferred guardianship. Before marriage, a woman was legally represented by her father or male kin. After marriage, that authority shifted to her husband. This was not symbolic, it was enforceable. The husband controlled property, household decisions, and public representation. He also controlled the narrative of her behavior. The law codes of Iceland and Norway reveal a critical imbalance. While women had certain rights, such as limited divorce under specific conditions, those rights existed alongside permissions granted to husbands that placed women in constant vulnerability. A husband was allowed to discipline his wife for perceived disobedience. The definition of disobedience was broad. It could include speech, refusal, or behavior deemed dishonorable. The law did not require witnesses. It trusted the husband's judgment. This was not described as cruelty. It was described as maintenance of order. Women accused of violating expected behavior could be subjected to severe mistreatment behind closed doors. The law did not ask how this discipline was carried out. It only cared that it did not result in public disruption. As long as the household remained outwardly stable, intervention was unlikely. Silence was interpreted as compliance. Survival was interpreted as acceptance. The fear this created was constant. A woman's safety depended not on innocence, but on perception. Accusations did not need proof.
Reputation could be shaped by rumor, and rumor carried legal weight. One of the most chilling aspects of Viking law was the treatment of so-called dishonor. If a woman was accused of bringing shame to her household, the consequences extended beyond punishment. She could be abandoned. Legal abandonment was not emotional separation, it was social erasure. A husband could repudiate his wife publicly, stripping her of protection. Once cast out, she lost access to property, kin alliances, and legal defense.
For many, this was a slow sentence rather than an immediate end. To be abandoned in this society was to exist without shelter in law. It exposed women to exploitation, forced dependency, or enslavement.
The law recognized this outcome and allowed it anyway. This is where Viking law crosses a line that modern viewers often miss. Death was not the only ultimate harm. There were fates designed to continue indefinitely. Fates that removed dignity, safety, and voice while keeping the body alive. Captured women, enslaved women, and women married into hostile households lived under constant surveillance. Their labor was expected. Their obedience was assumed. Their suffering was not recorded unless it disrupted male authority. Even then, the focus of legal proceedings was not on harm endured, but on property damaged or honor diminished. The system rewarded silence. By the late 10th century, Christianity had begun to influence Scandinavian law, but the transition was uneven.
Older customs persisted. While church teachings introduced ideas of moral restraint, enforcement remained local. Husbands still held decisive power within the home. Lawmakers did not enter domestic spaces. They trusted male heads of household to govern internally. For women, this meant that the most severe pressures were invisible to history. They left no runestones. They were not named in sagas unless their suffering served a male narrative. What remains are fragments, legal clauses, divorce provisions, and cautionary tales that hint at what was considered acceptable. One Icelandic law states that a woman may seek divorce if struck publicly. The condition matters, publicly. What happens in private is not addressed.
The implication is unmistakable. Private suffering was tolerated. Public disruption was not. This distinction reveals the core priority of the system. Stability mattered more than justice. Appearances mattered more than safety. A household that looked intact was valued over the well-being of the person inside it. The psychological impact of this cannot be overstated. Fear became internalized. Many women learned to anticipate anger, adjust behavior, and self-censor speech. This was not weakness, it was adaptation. Survival required constant calculation. Every word carried risk. Every action was measured against potential accusation. This is the quiet cruelty of legal oppression. It does not need chains or spectacle. It only needs authority and indifference. Midway through our investigation, it becomes clear that Viking law was not an accidental product of its time. It was a deliberate structure that privileged male control and normalized female endurance. If continuing to examine these systems matters to you, continuing this work with dark inquest history means refusing to accept sanitized versions of the past. As the Viking Age progressed, some women did push against these boundaries. Divorce petitions appear in the records. But even these acts came at a cost. A divorced woman faced suspicion, her reputation followed her, and the law offered no protection from retaliation beyond the written word. The darkest truth is this: Viking law did not need to kill women to destroy them.
It gave husbands the power to create lives defined by fear, dependency, and silence. That power was legal, it was respected, and it was rarely challenged. The law spoke calmly, the suffering remained quiet. By the early 11th century, the Viking world was no longer isolated by fjords and distance. Trade routes connected Scandinavia to Britain, Ireland, and continental Europe. New beliefs arrived alongside silk and silk. But inside the longhouses, the old legal realities remained. For women bound by marriage, the expansion of the world did not mean an expansion of protection. In many cases, it tightened control. Viking law treated the household as a closed unit. What happened inside it was considered the responsibility of the man who led it.
This principle was repeated across regional law codes. A husband was accountable to the community only if disorder spilled outward. If fear stayed contained, the law stayed silent.
This created a dangerous imbalance. The law defined men as guardians and women as dependents, yet it gave those guardians near total discretion. Oversight was minimal, intervention was rare, and when harm occurred, the burden of proof did not rest on the one with power. One of the most revealing aspects of Viking legal culture is how it framed women's testimony. A woman could speak in court, but her words carried less weight than a man's. In disputes involving marriage or household conduct, her credibility was often evaluated through her husband's reputation.
If he was considered honorable, her claims were weakened automatically. Law did not ask whether authority could be abused. It assumed authority was deserved. This assumption shaped every layer of domestic life. A husband could accuse his wife of disobedience, disrespect, or dishonor. These terms were intentionally vague. They allowed behavior to be judged subjectively. There was no fixed standard for what constituted acceptable conduct beyond obedience and silence. The law trusted men to interpret these boundaries, even when interpretation benefited them. Punishment under Viking law was rarely defined in detail. This was not restraint, it was permission. By avoiding specifics, the system avoided responsibility.
The outcome was predictable. Women lived under constant uncertainty, never knowing which action might provoke legal justification for harsh punishment. The most feared accusation was that of dishonor. Dishonor did not require proof of wrongdoing. It could be constructed through gossip, jealousy, or political advantage. A woman accused of dishonor endangered not only herself, but her entire household's standing. This pressure ensured compliance long before accusations were spoken aloud. If a husband chose to publicly declare his wife dishonorable, the consequences were immediate. Her protection evaporated, her legal identity fractured. She could be expelled from the household with little recourse.
In a society where survival depended on kin networks, this was not merely rejection, it was exposure. For many women, this was worse than death because it removed the possibility of dignity. It forced continued existence under hostile conditions, dependent on strangers, vulnerable to exploitation, and without legal voice. The law did not intervene because the process itself was legal. Enslaved women occupied an even more precarious position. Captured during raids or inherited through family lines, they were classified as property. The law acknowledged their humanity only insofar as it affected ownership. Their suffering was invisible unless it impacted a free man's assets. For them, marriage did not offer protection.
It offered transfer. Even free women were not immune to this logic. Marriage functioned as a controlled exchange. Dowries passed hands, alliances formed. A woman's consent was secondary to strategic advantage. Once married, her role was fixed. Any deviation from expectation was framed as defiance. What makes this system particularly chilling is how normal it was. There was no sense of scandal, no widespread moral outrage. These laws were recited publicly. Children grew up hearing them. They learned what was expected before they understood what it cost. The Sagas, often cited as evidence of strong Viking women, tell only part of the story. They celebrate exceptional figures, precisely because they were rare.
For every woman remembered for defiance, countless others learned that resistance carried consequences that the law would not prevent. By the midpoint of the Viking Age, some legal reforms appeared on the surface to benefit women. Divorce clauses allowed separation under specific conditions, but these clauses were narrow. They focused on public behavior, not private suffering. A woman could leave if publicly humiliated, but humiliation that occurred quietly did not qualify. This distinction reveals the true concern of the law: reputation. Public disorder threatened social stability, private suffering did not. A woman seeking divorce also faced retaliation.
Her former husband retained social influence.
Her future prospects diminished. The law permitted separation, but did not guarantee safety afterward. In practice, many women stayed, not because they lacked awareness, but because the alternative was worse. Halfway through this examination, the pattern becomes undeniable. Viking law did not merely tolerate cruelty, it structured it. By defining authority broadly and accountability narrowly, it allowed harm to persist without record. It created lives lived in anticipation of punishment rather than an expectation of protection. This is where the historical record grows thin. Women who endured these systems left few traces. Their silence was not consent, it was survival. Historians reconstruct their experiences through gaps, through what the law did not say, through what was never prohibited.
And yet, the impact of these laws shaped generations. Women learned to regulate themselves long before a man intervened. Fear became an internal mechanism. Obedience became instinctive. This is the most enduring legacy of such systems, control that no longer requires enforcement. If this investigation feels uncomfortable, it should. Understanding these structures is not about condemning the past for its difference. It is about recognizing how easily law can be used to legitimize suffering. Continuing to examine these histories with dark inquest history is not about blame, it is about clarity. As Christianity gained influence, some practices softened, language shifted, but power dynamics did not disappear overnight.
The law adapted rather than transformed. Many women remained trapped between old customs and new moral codes that still prioritized male authority. By the end of the Viking Age, the legal systems had changed names, but their foundations endured. The household remained a private domain. The husband remained its unquestioned authority, and women remained vulnerable to laws that protected order over humanity. What Viking law allowed husbands to do was not always visible. It did not need spectacle. It relied on silence, fear, and the certainty that no one would intervene. That is what made it worse than death. As the Viking Age moved toward its end, the laws that governed marriage did not disappear.
They settled into custom. What had once been recited aloud at assemblies became expectation, habit, and inherited behavior. For women, this meant that even as political structure shifted, the weight of domestic authority remained unchanged. The danger was no longer only in what the law explicitly allowed, but in what it taught people to accept. By the 11th century, many Scandinavian regions had begun to formalize kingship. Written law codes emerged. Christianity spread through courts and councils. Yet within households, enforcement still relied on the same principle. The man was responsible and therefore unquestionable. The private space of marriage remained outside meaningful scrutiny.
Women who lived under these systems learned early that protection was conditional. It depended on usefulness, silence, and reputation. A woman who fulfilled her expected role was described as honorable. One who challenged it risked being labeled disruptive. That label alone could justify severe consequences without a single act needing to be described or proven. The most effective form of control was uncertainty. The law did not specify boundaries clearly because clarity would have limited authority. Instead, women were left to navigate shifting expectations. What was acceptable one day could be condemned the next. This instability kept power firmly in male hands. The emotional cost of this structure is rarely addressed in popular history.
Fear was not occasional. It was constant. It shaped posture, speech, and decision-making. Many women lived with the understanding that safety was temporary and revocable. This was not accidental. Systems built on dominance rely on insecurity to function. Some historians point to inheritance laws as evidence of Viking women's relative strength. It is true that women could inherit property under certain conditions, but inheritance did not equal autonomy. Property was often managed by male relatives or husbands. Ownership existed on paper, while control remained elsewhere. Legal recognition did not translate into lived freedom. The sagas again offer contrast. They present women who speak boldly, who manipulate outcomes, who influence events.
But these stories were preserved because they entertained and reinforced values admired by male audiences. They do not represent the average experience. They represent exceptions that prove the rule. For most women, resistance was quiet. It took the form of endurance rather than confrontation. Leaving was dangerous. Speaking was risky. Compliance became the safest option available. This is why the harm inflicted by Viking law cannot be measured only by documented punishments. It must be understood through behavior shaped by fear. In many cases, the harshest consequences came not from action, but from accusation. A husband did not need to demonstrate harm. He needed only to claim disruption.
The law supported his authority to restore order. How that restoration occurred was not examined. This absence of scrutiny allowed abuse to hide behind respectability. A man who appeared lawful in public was assumed to be lawful in private. A woman who survived was assumed to be unharmed. The law equated endurance with consent. What makes this system especially disturbing is that it was reinforced by community silence. Neighbors did not intervene. Kin avoided involvement. To challenge a household head was to invite conflict. Stability was valued over intervention. This collective disengagement ensured that suffering remained invisible. By the time Christian courts attempted to introduce new moral language, much of the damage had already been normalized.
Teachings about compassion existed alongside laws that still deferred to male authority. The contradiction was rarely resolved in favor of women. At this point in our examination, it becomes clear that the phrase "worse than death" is not rhetorical. Death ends suffering. The lives shaped by these laws extended suffering indefinitely. They removed the possibility of escape while preserving the appearance of order. This is the kind of harm history struggles to record. It leaves no battlefield, no mass grave, only patterns of silence passed from generation to generation. If examining how law quietly legitimizes suffering matters to you, continuing this work with dark inquest history means choosing to look where history preferred not to.
By the late medieval period, Scandinavian legal systems had transformed again. Centralized authority increased, written records improved. Yet even then, the legacy of Viking-era domestic control lingered. Cultural memory outlives statutes. Practices justified once are not easily abandoned. Women continued to be judged through obedience. Marriage continued to function as a site of control. And the idea that what happened inside a household was private endured long after the Viking Age itself had faded. This continuity is the final indictment of the system. Viking law did not simply allow husbands power in a moment of history. It established a model, one that taught later societies how to excuse harm by calling it order.
The darkest laws are not the ones that shock immediately. They are the ones that endure quietly, shaping lives without ever naming what they destroy. When we look back at the Viking world, it is tempting to search for a moment of reckoning, a reform, a collapse, a clear end to the authority these laws granted. But history rarely offers clean conclusions. What happened instead was absorption. The most severe permissions faded from written law, yet their logic survived in custom, expectation, and silence. By the 12th century, Scandinavian societies were officially Christian kingdoms. Kings replaced assemblies. Written codes replaced memory. On the surface, this looked like progress, but within marriage, the balance of power shifted slowly, unevenly, and often only in language.
The household remained a private domain.
Authority remained concentrated, and women continued to live with the inherited consequences of earlier legal structures. What Viking law allowed husbands to do did not vanish. It was renamed. It was softened in wording. It was justified differently. But the core assumption that control within marriage was necessary for order persisted. The suffering became harder to see, not because it ended, but because it adapted. This is why these stories matter. The women who lived under these systems did not leave behind manifestos, they left behind patterns. Sudden disappearances from records, property transfers without explanation, divorce clauses that hint at public limits but remain silent about private realities.
Their experiences survive not in detail, but in absence. History often praises Viking society for its resilience and structure. But structure is not neutral. It always serves someone. In this case, it served men whose authority was protected even when it caused harm. The law did not ask whether power was abused. It asked only whether order was maintained. For the women who endured this, survival required adjustment rather than justice. They learned when to speak and when to remain silent. They learned how to anticipate anger. They learned that the law would not intervene unless appearances were disturbed. This knowledge shaped lives from childhood to old age. And this is the final truth. The greatest damage done by Viking law was not the individual acts it permitted, but the mindset it enforced.
It taught an entire society that suffering could be acceptable if it was quiet, that harm could be lawful if it preserved stability, that endurance could be mistaken for consent. History did not record these women as victims because the system did not define them as such. It defined them as dependents, responsibilities, or problems to be managed. Their pain was never the subject, order was. When we say that what Viking law allowed husbands to do was worse than death, we are not speaking in metaphor. We are describing lives shaped by fear without release, control without oversight, and silence without remedy. Death ends a story. This system forced women to live inside one that could not be spoken.
Remembering this is not about judging the past by modern standards. It is about refusing to let legality excuse cruelty. It is about understanding how power hides behind tradition and how easily suffering can be normalized when it is pushed out of sight. If preserving the memory of those history trained itself to ignore matters to you, then continue this work with dark inquest history, not for outrage, not for spectacle, but to keep examining the systems that taught silence and the lives that paid the price for it. Because the most dangerous laws are not the ones written to punish, they are the ones written to make suffering disappear.